Good morning. Urban governance, fantastic things. One quick question. What happens to the output of urban governance? Is that legal? Can you file it in a court of law? Can you rely it as evidence? That's one big question mark that invariably urban governance and urban governments don't consider. Today, we have to realize that we have a legal framework in the country. This is the Information Technology Act 2000. And whatever you do in urban governance has to ensure compliance with the IT Act and the rules and regulations made thereunder. Now, 11th of April 2011 has been a very watershed day in the history of India. You'll say, what happened on that day? Nothing happened. Well, nothing happened except quietly a set of notifications were issued by the government of India. These notifications mandate huge amount of responsibilities for people, for entities who provide electronic services and their delivery on networks. Various new guidelines and parameters of compliance have now been stipulated. More importantly, way back in 2008, when the IT Act was implemented, there was a change in the law which impacted urban governance, but which is not being talked much in day-to-day. Why? Because it's not convenient. But let's face it, the law came up with a new definition or new concept of an intermediary. Intermediary with respect to any particular electronic records is defined by Section 21W of the IT Act to mean any legal entity who on behalf of another person stores, transmits or publishes that record or provides any service with respect to that record, and includes network service providers, telecom service providers and the like. The definition of intermediary is so vast that all government departments, all urban governments qualify as intermediaries under the IT Act. The moment you are an intermediary, you are exposed to certain set limited liabilities under the IT Act. One liability is a criminal liability, and the criminal liability could be for the concerned head of the department of that particular urban governance project. The criminal liability could expose him from 3 years to life imprisonment. In addition, there's also an exposure to the government for being sued for damages by way of compensation up to 5 crore rupees per contravention. And that's the two kinds of exposure that have come in. Governments are continuing to do them urban governance projects, but are still not alive with the fact that they will need to limit their liability. Unfortunately, the law is ruthless. The law has not carved out an exception from liability for the governments. So my 2 points, that governments and urban governments will have to ensure documented due diligence under Section 79 of the IT Act, because these guys are intermediaries, these guys are dealing with third-party data, your and my data, and they are handling, processing and dealing with data. And more importantly, governments will also have to realize that the government has quietly notified what's known as sensitive personal information. So anything which pertains to your biometrics is sensitive personal information. Passwords are sensitive personal information. Bank records, credit card details, sexual orientations, health records are all sensitive personal information. Huge amount of new compliances have come under the law pertaining to these, and I think as time goes across, urban governments will have to be more alive to the fact that they will have to ensure compliances with the IT Act in order to ensure that their exposure to liability is reduced at the bare minimum. Thank you, ladies and gentlemen.